All right. Good afternoon. Welcome, counsel, to an oral argument session, the Fifth District Court of Appeal. We have one case on the docket here at 3:30. It's the case of Stephen Schrader versus the state of Florida. I have joining me on the panel today, my name is Rand Wallace. I'm a resident of Seminole County, and I have joining with me Judge Jay Cohen from Orange County and Judge Eric Eisnagel from Seminole County. We have 20 minutes per side for these oral arguments. We've been having a little issue with the Wi-Fi here at the courthouse as it would affect the time that you see on the screen. If that goes out for any reason, I'm going to keep the time as well. So it's still 20 minutes, and I'm going to assume the appellant wants 5 minutes for rebuttal unless you tell me differently, Mr. McLean. And yes, just make sure you're on mute if you're not speaking so that it doesn't disrupt the presentation of the arguments. And with that, Mr. McLean, you may proceed.
Good afternoon, Matthew McLean on behalf of Stephen Schrader. We raised 4 issues on appeal. Let's start with the first issue. In this issue, the state charged a single count of lewd lascivious molestation. Within that count, they alleged a number of acts. Those acts included touching of the vaginal area or the genital area or the buttocks.
That was alleged alternatively, was it not?
Correct. They alleged alternative theories and they pursued alternative theories at trial. Our position is case law is pretty clear that a child victim's prior inconsistent statement standing by itself is insufficient legally to sustain a conviction. The due process clause requires that a conviction.
Well, the child testified at trial, and I assume that you're referring to the fact that she backed off of her statement. That might be a poor choice of words in terms of the touching of her buttocks. Correct?
That's correct.
Okay, but certainly the child, got on the stand, and it appeared from my reading of the record that. When asked where she was touched, pointed not just to her tummy, but was able to point to her vaginal area. At least that was my reading of the record. Why is that wrong?
Well, I think that goes to the second issue. Certainly, there was confusion expressed by the child as to where her front private part was. And whether she could distinguish between her belly and her vaginal area. And she never used the word genitals, vagina, just front private, and that caused some confusion within the record. So I don't believe that there is sufficient evidence that the child actually made statements that the area touched was her genital area.
Wasn't there also independent testimony from, I believe it was the maternal grandfather, correct me if I'm wrong, that saw injury to her vaginal area?
The paternal grandparents did testify as to what caused them concerns and what their beliefs were in the case. They originally referred to a scratch on her inner thigh where perhaps a bathing suit would be and there'd be chafing. The paternal grandmother also took a picture of her vaginal area, which she described as being red and gaping. But that was more going towards why she went ahead and started talking to the child about did anything occur. There was no sort of expert opinion that would be consistent with the allegations that the child was making.
Was there a requirement for the child to refer to her private area as her vaginal area?
I think the statute makes clear that the area that has to be touched is the genital area. So I think there has to be clear evidence presented by the state to prove beyond a reasonable doubt that she's referring to her genital area.
But does the clear evidence have to be her specifically referring it to using an anatomically correct description of the area?
I don't think so. I don't think there has to be any sort of magical words being used, but there has to be some sort of definitive statement that this is where he touched me. When asked about private parts, she referred to her belly button as being her private part, her belly being.
Oh, but then later she gets on the stand or she's asked to point and distinguishes between her belly button and her vaginal area, does she not?
She does. The way the questioning is asked is a little, I think misleading. The prosecutor first asked, "Can you point to your belly button?" which she had previously described as a private part, and then she said, "Can you refer to your front private part?" And she pointed to an area that the record makes it appear that it's maybe the genital area, but there's no video evidence of what it is that she's pointing to. But I think the biggest thing is that there's confusion among this child as to what her front private part is. And so there is a possibility that he did not actually touch her genital area. So that's the argument to count two, or the claim
Counsel,
two.
assuming that there was some confusion, why is that not an issue that is for the jury?
Well, I think because it's the state's burden to show beyond a reasonable doubt, and the due process clause requires that to be proven. And so if they can't,
shouldn't you be talking about what shouldn't you be arguing that there's no competent substantial evidence, as opposed to that there was some confusion in the evidence?
Yes, and I'll concede that this probably isn't my strongest point on appeal, but because of the confusion raised by the child, that's why I went ahead and included it in the brief, as also to help substantiate the first claim and the error that occurred there. So if I could,
well, then why don't you go ahead, and then maybe it was my fault in distracting you from what you perceive to be your strongest issue on appeal. Why don't you go ahead and talk about that then?
Okay, so the first issue is what I perceive to be the strongest issue, and the reason why is because there is no testimony at trial from the victim that he ever touched her buttocks. The only evidence that came in, substantive evidence, was the child interview that was played for the jury, in which she described two different incidents where he touched her buttocks area.
Yeah, but can't he have been convicted based upon the alleged touching of her vaginal area?
It's possible, but there's a general verdict, so we don't know under which theory the state actually got the conviction under. And seeing
and
as
was there a request for an interrogatory verdict of any sort?
There was not. This issue really went unnoticed by defense counsel, the prosecutor, and the trial court. So the whole trial proceeded even after, and I believe the state knew from the beginning, because they didn't ask a single question to this child during direct examination about a touching of the buttocks.
And did they argue on closing argument that he should be convicted based upon a touching of her buttocks?
Yes, they did. They said, look, all we have to do is prove one time, one act. It can be the vaginal area, it can be the buttocks. We only have to prove it once. So they certainly benefited from it. The jury was instructed on it. There's a number of record citations that I provided, and provided block quotation of where the state is making this dual argument to the jury, pages 338, 340, 353, 357, 360, 367. That's all their initial closing. And then in rebuttal, 392 and 397. So this
Mr. McLean, the defense brought out or used cross-examination to examine the victim and specifically focused on the first and the last interactions. Is that correct? Specifically with regard to touching the buttocks.
They definitely asked questions regarding the first and the last incident. They also asked the child, do you remember any other incident? And she said no. There's testimony about slapping the buttocks. Is that correct? That's correct. Not testimony from the child at the trial, but in the interview with the child protection team, there was statements made by the child about, spanking or slapping of the buttocks in the first incident.
Okay, so that was also limited to the first incident?
Correct. And then the final incident is, her talking about hand sanitizer, the smell associated with it, and him rubbing her back private, multiple times while he had this sort of hand sanitizer is what she called it. But when it comes down to it, and I think the state, conceded the point, but then went on to argue that, maybe the child was somehow misled or not asked the right questions during the trial. But the point is that it's the state's burden to prove beyond a reasonable doubt that this actually happened. There's literally no testimony from the child that there's any touching of the buttocks.
But if there's alleged in the information alternative methods of proving the offense, and there was sufficient evidence to support a conviction for touching of the vaginal area, how is there reversible error?
Well, there's a few cases that we provided the court, Fitzpatrick, Delgado, and I believe the other case is Mackerly. And in those cases where they're talking about premeditation, felony murder, they talk about, there might be sufficient evidence of premeditation the jury could have found, but there was not legally adequate evidence to go ahead and substantiate.
But those are alternative legal theories, as opposed to factual, assertions within an information.
That's a good distinction that Your Honor makes, but I don't think it really impacts the case because the jury was clearly misled in this case through the jury instructions, through the closing argument.
Was there an objection to the jury instructions?
There was no objection. This is pure fundamental error that we're alleging here, and it's based off a due process violation of making the state sure that they prove the case beyond a reasonable doubt. So we look at other cases that also provide guidance, and those are, when the state in their jury instructions, they go ahead and they allege a specific act, and then they instruct the jury on acts that went uncharged. And in that context, I gave an example with trafficking cocaine. I gave one in the context of a child molestation case. When there's evidence that the jury was improperly instructed on uncharged acts, which is also a due process violation, the court has found fundamental error because the general verdict form makes it impossible for us to know, is he being convicted of a offense that is not supported by legally adequate evidence. So when we look at all these cases together, they support the conclusion that fundamental error did occur in this case, and he should be entitled to a new trial on the only evidence that can sustain a conviction in this case, which is touching of the front private part. And
it was charged, though, counsel, right? It was charged, and the jury instruction was consistent with the information, correct?
That's correct. But
your argument is more to the evidence, right? Or in your view, the lack of evidence on the alternative factual charge, right?
Correct. And, I think it really kind of, it wasn't decided by the state, but the 2-issue rule talks about, a jury can go ahead and determine factual determinations. Look, the state didn't present sufficient facts of premeditation, but where the problem becomes an issue is when they are not able to legally recognize something. So in this case, they're never told that a prior inconsistent statement by itself is legally inadequate to sustain a conviction beyond a reasonable doubt. So there's nothing there to protect them from making a decision in their verdict that would be an improper basis for the conviction. And so Your Honor was making reference to charges that were not charged in the information being instructed. That's a due process violation. And in the Bieber case, BER case, the court has found, due process is violated when a charge isn't proved beyond a reasonable doubt. So they're both dealing with due process violations, and that's why they constitute fundamental error.
In this case, counsel, the charge, there was substantial competent evidence to prove the charge as charged in the information, right?
I can't concede that point based off the second issue.
If we were to agree that the charge relating to touching of the buttocks was not proven by competent evidence, but that the touching of the front private was, then the information as charged was supported by competent substantial evidence, correct? Yes?
I don't think the problem is with the information. I think that if that is accepted as true, then there would be an adequate basis for a verdict in the case. But then we go to the problem is with a general verdict, we just don't know. And
but counsel, who's, you're on appeal. Who has the burden there?
Oh, we have the burden, especially in fundamental error, to show something that reaches down into the validity of the verdict in this case. And so that's why we cited these cases that talk about missteps in charging or instructing on uncharged acts. That's why we talked about cases where there was legally inadequate.
But counsel, these acts were charged. That's where you're losing me.
Well, I guess I would point more towards the premeditation felony murder line of cases where both of those are charged. But there's one that is legally inadequate and one that there could be adequate evidence of. And the judges said that that's fundamental error. And those are Florida Supreme Court cases stemming from, I believe, 2001. So in that similar situation, both are charged offenses under, or once you charge premeditated murder, felony murder is also included in that. So if you have an issue where a jury can't distinguish legally whether they can convict, then fundamental error does occur. I would like to briefly address the last issue in the case as well, if I may. That involves the closing argument in this case. It's our position that the prosecutor simply relied on evidence not in the record. They went ahead and argued to the jury that a 6-year-old would not be essentially capable. Didn't say as much in these words, but simply implied that a 6-year-old would not be capable of making these type of details and these type of assertions up. There's a case law that came out after my initial brief was filed, so I filed the amended initial brief based off of it, and that's the Amarellis case. And I believe that when the closing argument in this case is compared to the closing argument in the 4TCA case, they're pretty much identical. And the 4TCA found that comment by itself constituted error. It was not harmless, and went ahead and reversed for a new trial just based off that one statement in closing. If there are no questions immediately on that issue, I'll reserve the rest of my time for rebuttal.
Okay, Mr. McLean, you have about, by my clock, you've got about four minutes left. Okay.
I'll take it. Thanks.
All right, Mr. Bradford, you may proceed.
Thank you. Thank you. Good afternoon. My name is Roberts Bradford, and I represent the state of Florida in this action. With respect to the first issue, the buttocks touching issue, there's no doubt that it's not a preserved issue. And our position that it's not fundamental either, in light of the overwhelming evidence of the touching of the genitals, which I'll get into further in just a minute. It didn't go to the foundation of the case, which is the common theme for fundamental error. It has to reach down into the validity of the verdict such that it could not have been obtained but for the error. If there's competent substantial evidence to support the genitalia touching, then that question is over and this is not a fundamental issue. Assuming arguendo that there was a preservation or that this court should consider the issue further, while I certainly don't disagree with my colleague's interpretation of the Baugh case, I think it has limited application in this particular case. As the court noted, the victim in this case was cross-examined with respect to the first incident, acknowledged that she couldn't remember the next incident, didn't talk about any other incidents. And then
you can keep going. I have the time. You can go.
Very well. And then at the last incident, and it's clear in the last incident, she said there was no buttocks touching, and I'm not going to argue that. But I'm not so sure that the first incident, that the statement is a prior inconsistent statement, in light of the fact that there was, in the forensic interview, the statement was that he spanked my bottom and he didn't have a reason to. I think it's reasonable, when you take it in a light most favorable to the state, that the jury can conclude that a 9-year-old girl would see a difference between touching and spanking. But even setting that aside,
Mr. Bradford, do you think that there was competent substantial evidence to support a conviction for the touching of the buttocks in a lewd and lascivious manner?
I do, Your Honor. She said in the forensic statement that he touched my front privates and back privates a lot. She testified that the molestation occurred so frequently that she learned to go with her grandmother to the store, because if she didn't, she knew he was going to do it. And there was the hand sanitizer incident as well. And while she certainly did say she agreed with the defense lawyer that he never touched my buttocks, that was in the context of, I'm going to ask you about the first incident. And then she said, I don't remember him touching anything else, or he didn't touch my buttocks. I'm going to ask you about the last incident. Yeah, he didn't touch my buttocks then. So he didn't touch your buttocks in any of these incidents? No, he did not. Any of these incidents is the first and the last. That's it, because that's all she was being asked about. She testified on direct and and she stated in the forensic interview that it happened frequently. So the Baugh case, the limited application, if it applies at all, would be to the first and the last incident only. And therefore the statements, the pretrial statements made with respect to her buttocks being touched are not prior inconsistent statements. They are not recanted testimony. So to the extent that there was any buttocks touching during the time period alleged in the information, other than the first incident and the last incident, Baugh case doesn't apply, and this would be substantive evidence. Whether it needs to be corroborated or not, I submit that it does not, but assuming arguendo that it does, I think there is corroboration. The paternal grandparents testified, both testified. The grandmother testified that there was an injury to the skin. She called it an excoriated type injury, and rubbing abrasion kind of, as I understand it. She took a picture, which was admitted as State's Exhibit 3. The victim is in a position where basically it's as if she's getting her diaper changed, laying on her back with her legs up. You can easily see in State's Exhibit 3, the red area that the grandparents are talking about that they testified to, and it extends from the inner thigh, which is how the grandmother described it. But then the grandfather described it as extending, well, it's down in the picture, but it would be up the back of the leg, up into the crease between the, I believe he said, the bottom of the body and the top of the leg. Well, the bottom of the body is the buttocks, as I understand his testimony. And so therefore, I believe that would be competent, substantial evidence to corroborate not only his testimony, but the grandmother's testimony and State's Exhibit 3. And so therefore, there is competent, substantial evidence to support the jury's finding with respect to the buttocks touching. Now, as to the second issue with respect to the front privates issue or the genitalia, the 9-year-old victim who was testifying in a courtroom full of strangers about having been molested by a gentleman sitting just a few feet across the way from her, she didn't have any difficulty in distinguishing between her belly and her front privates, her genital area. And that was, I think, clarified when she stood up in front of the jury, and at the request of the prosecutor, she pointed to what she meant by her front privates, and she pointed to her belly button, and those were described as two different things in the record. But she went beyond that, and she says, when I mean front privates, I mean between my legs. And then additionally, the third support for that would be the anatomical drawing of during the forensic interview, in which she correctly identified the genital area and the buttocks area as the front and back privates, which is how she referred to them during the interview as well. So she didn't have any issue. And quite frankly, if she had used the terms genitals or he rubbed my vagina, quite frankly, I think that Mr. Schrader would be standing up screaming that she had been coached, because those were adult words. And you could basically say that this was kind of a reconfiguration of the impact of a child victim using the language of a child.
Was there an objection to the interview, admission of the interview?
I don't believe there was. There that a hearing pre-trial. Actually, I can't say right off for certain off the top of my head. I don't recall there being any issue raised. Certainly wasn't raised on appeal. So if it had been raised below, it was abandoned. With respect to the third issue, the restricted impeachment, the proffer in that
Well,
case.
assuming that the interview was improperly admitted because assuming for a moment that it was, that there was a recantation, right, and that it wasn't substantive evidence, then would it have been on the responsibility of the defendant to make a motion of some sort or lodge an objection?
Well, as to the use of the forensic as substantive evidence?
To admission of the interview where she talks about the touching of the buttocks.
I'm sorry, Your Honor, what was your question? I don't think that there was, again, I don't remember an objection.
Well, they complain about the fact that the state talked about this portion of the evidence, relying at least in large part on the interview, right? They complain about the fact that was brought up in closing argument. And my only question is what was there any objection lodged by the defendant to the interview or that portion of the interview?
Well, certainly there was the hearing pre-trial as to the admissibility of the child hearsay statements. They were ruled admissible. I'm sure Mr. McLean.
Was there a specific argument based upon the touching of the buttocks being a recanted testimony, if you will?
That I don't think so. No, I
that
don't.
Would be the issue we're talking about right now, right?
You're correct. You're right. And as specific as the court has just made it with respect to the buttocks, no, I don't think there was a specific buttocks issue objection. I think
when it comes to preservation, doesn't the objection have to be specific?
It does.
They can't just object to the entire interview for some general reason and then say on appeal, well, hey, look, the specific reason is that this part of the interview was improper, right?
That's correct. That would, in fact, I think I addressed that or would with respect to the closing argument issue when the objection was improper argument, and there's case law precedent that says that's simply legally insufficient as an objection because you don't put the court on notice of what your actual objection is.
What about the testimony that the child had? I don't know whether you would term it a reputation, but there was evidence that the child lied on a fairly regular basis.
Yes, so the proffer in that case was, and this is the total extent of the proffer. It's at pages 121 and 122 of the trial transcript. Your dad talked to you about lying when you were younger, you lied a lot about a lot of things. Yes. And your dad told you needed to stop. Yes. That's the extent of the proffer. That's it. And that's simply insufficient, both from a foundation point of view as well as a relevance point of view.
And what foundation would have to be laid?
The foundation, they first have to establish that there is a reputation in the community for a 9-year-old to have a reputation.
Right. And so how do you do that? How do you establish a community of 9-year-olds?
That's our position is you can't. I don't know that
Ever.
any community
ever. So no one could do that. No one ever could impeach a child with lack of veracity.
Well, I think that kind of goes to the second part of the argument in that we don't really know what this proffer means, because when she was younger, after the incident, after the investigation, before the trial, how would that have any bearing on her testimony? Certainly.
My question was how do you establish a community for a 9-year-old or a 7-year-old or a 6-year-old?
Could be amongst her. Well, she was 9 at the time. I mean, it could be amongst her classroom, amongst her in her school, amongst her if she goes to church or her Sunday school class.
So,
I'd love to see the objections raised to a defense lawyer that started to try to take depositions of her classmates in school and the people at church.
So you have to depose the 4th grade class.
You prove the community this for a child the same way you prove the community for an adult. It's her peers, her colleagues, it's the people around her. I understand
It couldn't be 12 aunts and uncles.
Well, that's not what was proffered. The proffered was dad. Now there was some discussion, I think.
Judge Cohen just simply asked you a very broad question. How could one do it?
And I think the same way they could do it for an adult.
So, I mean, you're not saying that they would have to go into the 4th grade class and depose a bunch of kids. They could theoretically bring in 10 aunts and uncles, right?
Well, the Lott versus State case says that you can't use family members. They can't be on personal interactions. It has to be a reputation in the community. And the community is not family, according to the Lott versus State case. So that's wrong, first of all.
Yeah, I know, and this is a hypothetical. I realized I don't think the proffer in this case was adequate. It's an issue that has troubled me.
And probably rightfully so, but it makes the rules of evidence make no exception for child witnesses. And so
the point I was trying to get at, counsel, is that you're not saying that it has to be other 6-year-olds.
No,
Okay.
no, not at all. Not at all. Frankly, it could be in the general larger community, but there was no evidence that she had a reputation. There was no evidence that she knew she had a reputation. And those are both in and of themselves failures, foundationally speaking. And then, of course, there was the improper community under Lott. But again, we don't even know what younger means. It could have been from the time that the criminal investigation was concluded up until before trial. And certainly there's no probative value in that case, or the slight probative value is substantially outweighed by the danger of unfair prejudice in light of the fact of the importance of her testimony in this case. And then finally, with respect to the bolstering issue, again, I don't think it's preserved. Improper argument is not a legally sufficient objection. It's not fundamental because the heart of the case is not whether all children will falsely accuse someone when they're angry. In fact, there was plenty of evidence of guilt with respect to the forensic interview, the grandparents' testimony, states.
But the supplemental, the authority mentioned and then addressed in the amended brief, do you see a distinction between the questions asked in that case and in the questions asked or the argument made, I should say argument made really, about whether, that 6-year-olds wouldn't make this up? Do you think that argument was different in this case than it was in
Very much so. Very much.
Well, explain how you see the difference in
the prosecutor
situation.
The prosecutor in this case basically presented the other side of the coin that the defense lawyer had presented during her closing. She had said that it's reasonable to think that the grandmother's statement that Stephen must have done it and are continuing to talk to the victim about this over the next few weeks influenced the victim's testimony. Is that reasonable? Absolutely. Okay. And then the prosecutor gets up and agrees that yes, it is reasonable that a child will falsely accuse somebody out of anger, although they said there's no evidence of it here. And then the objectionable part came up, or what's been argued as objectionable, whether or not a 6-year-old likes to do the dishes or likes to be spanked with a belt. It's reasonable that a child doesn't like that, but still isn't going to make up all the details, basically falsely accuse somebody. And while it does use the word details, and I think that's the link to the other cases where in those cases, the prosecutor argued a child will not, more of a universal, globally accepted principle that a child cannot do that or will not do that under certain circumstances. That's not what this prosecutor said. This prosecutor simply said, it's reasonable that they won't. It's reasonable that they will. It's reasonable that they won't. And that's not a concept that needs expert testimony in support. That is a common life experience that probably every adult has had in their life, certainly every parent and probably most non-parents, I would assume. If a child necessarily would falsely accuse somebody of sexual molestation every time they're angry. The courts would be inundated, absolutely inundated. Children, they make up things. And this goes back to the last issue with respect to the impeachments. They make up things as far as false friends, imaginary friends, or, I'm a princess or I'm a prince or whatever. I mean, that's a far cry from so-and-so molested. So when the prosecutor basically said that it's reasonable that not all children will do this under these same circumstances, that wasn't a blanket, no child will. It's just that not every child will. Simply the other side of the same coin that the defense lawyer had presented to the jury. If there are no further questions, then I'll rely on my answer brief for any further argument, and I would ask that this court affirm the judgment sentence. Thank you.
You still have 2 minutes and 45 seconds left, though.
I do.
All right. Okay.
Mr. McLean, you've got 4 minutes left.
Okay, thank you. Starting with the final issue regarding closing arguments, the preservation issue, there's no magical words that a defense counsel has to go ahead and say the purpose of objecting is to put the court on notice that there's something wrong and that they can take corrective action. You can see based off the transcripts, it was an instantaneous objection followed by an instantaneous ruling, perhaps even mid-sentence with the prosecutor not even stopping. Believe that the court certainly was on notice that this was improper argument. If they wanted further argument, they could have stopped proceeding and had that. The state also makes mention that
quote the precise language that you think was objectionable.
The precise language. I think Mr. Bradford, quoted it, but it's the latter part of the issue when they go ahead and start talking about a child, not this child, a child wouldn't be able to come up with these details. That's where it crosses the line and it enters into the territory of the Almorelis case because they're making generalities of children, which there's no evidence of. So it's fairly interpreted as children aren't capable of making up these details, and that's the problem. And the prosecutor.
So would it be your position that anytime a prosecutor uses the phrase "a child" as opposed to "this child," that runs afoul of the law?
Unless there's evidence in the record that children don't do those things, then yes, I would. You need to talk about the evidence contained in the case. And when you look at the state's argument that, well, the defense counsel, might have made objectionable comments as well. The Almorelis case also talks about that. Just because defense counsel says something and you find it objectionable, object to it. They didn't object to it, but that doesn't support a reason for you to then go forward and make an objectionable argument and then proper argument.
All right, but you would acknowledge though that that it's not per se reversible error, that it's still subject to the harmless error analysis.
Certainly subject to the harmless error analysis, and in a case where it comes down to a child victim's credibility and there's no physical evidence to substantiate it.
Well, don't these cases always come down to a child witness's reliability?
Yes, that's why I think that there are frequently cases reversed in these type of cases because the evidence is so scarce. You see similar arguments made by the prosecutor as to, well, children wouldn't do this, children wouldn't do that. It's the same argument repeated over and over again. It just changes based off the circumstances. And these arguments that the prosecution makes, I see them in a lot of cases that I've done, and they just go ahead and try to bolster their case improperly. Regarding the reputation evidence, which is the third issue, and the motion limiting proceeding, there was discussion between the prosecution and defense counsel, and the prosecution actually said, well, in depositions, we recognize that the Van Horns, meaning both grandparents, paternal grandparents, and the dad had to tell this child, you need to stop lying. And then in the proffer, can't someone be familiar with their own reputation in the community? Yeah, I lie a lot. I'd have been talked to. It's not just I lied sometimes, I lied a lot. Certainly that should be enough to go ahead in this type of situation where community of a 6-year-old is much smaller to go ahead and be admissible evidence. Finally, just reference the court to the Mendez decision, which found fundamental error where the state presented legally insufficient evidence of a touching based off prior inconsistent statement alone. Based off the arguments presented today, the arguments presented in the briefs, we ask that the court reverse for a new trial.
All right. Thank you, counsel, for your arguments. And it was a
Well argued case.
I
Thank you
agree.
very much.
And you all have a nice day.
You as
Thank
well.
you.